Hi, this is Nick Ritelli, your Ethics and Conflicts Counsel in Des Moines with today's video brief. On Friday, the Supreme Court handed down its decision in Freedom Financial Bank versus the state of Boesen that's certain to send chills up the spine of all of us who ever took a property law course. As stated by Justice Waterman, venerable precedent dating back to the 1870s guides our resolution of the competing claims. This case deals with concepts of season, the inchoate right of dower, legal fictions, and coverture. The only thing that's missing is Blackacre. The case presents the question, was there coverture of ownership in the husband without Freedom Financial's mortgage lien, to which the spouse's inchoate right of dower attached? Got it? Let's go to Suzanne for today's video brief.
Freedom Financial versus Boesen, decided November 18, 2011 by the Iowa Supreme Court. Freedom Financial versus Boesen asks the question whether the inchoate right of dower is superior to a mortgage, and if not, whether it is superior to other estate debts. Ed Boesen purchased commercial property in Ankeny, Iowa by obtaining a mortgage from Freedom Financial. The mortgage was purportedly signed by Ed and his wife, Maureen. Upon Ed's death, Freedom Financial foreclosed on the property. Maureen defended by claiming that her signature was a forgery, a claim that everyone accepted as true. Maureen claimed that because she did not sign the mortgage, her dower interest in the property was superior to the bank's mortgage interest. Freedom Financial countered by stating that even if Maureen did not sign the mortgage was a purchase money mortgage which was superior to her dower interest. Supposedly, the property was worth more than the mortgage debt, so when it was sold there would be a surplus. The surplus would be paid into the estate, where it would be subject to other debts and claims against the estate. Maureen claimed that even if her dower interest was inferior to the bank's mortgage, it did attach to any surplus that would be paid into the estate and was superior to the debts and claims against the estate. The district court ruled that under Iowa Code Section 654.12b, the bank held a purchase money mortgage superior to any other right, title, or interest arising through or under Edward. The district court concluded that Maureen's statutory dower right was a real property interest arising through Edward and was inferior to the mortgage. It ordered that any foreclosure sale surplus was to be paid to the estate, implicitly concluding Maureen's statutory dower interest under Section 633.211 was subject to the estate's debts and charges. At issue, two statutes which are codifications of the common law, 633.211 sub 1, codifying spousal dower, and 654.12 sub b sub 2, codifying priority of purchase money mortgages. Iowa Code Section 633.211 sub 1, the Iowa Dower Statute, Maureen and the estate argue her statutory dower interest attached to the Ankeny property when Edward purchased the land, and he could not unilaterally convey away her dower interest in real property. Iowa Code Section 654.12b sub 2, Iowa Purchase Money Mortgage Statute, making a recorded purchase money mortgage superior to any other interest arising directly or indirectly through the purchaser. While the purchase money mortgage statute would appear to trump the dower statute, Maureen argued that her dower interest was superior because she did not sign the mortgage, and Edward, her spouse, could not unilaterally convey her statutory dower interest, which attached the instant Edward purchased the land. The deed was filed 1 minute before the mortgage. Maureen cited the 1908 case of Warner v. Trustees of Norwegian Cemetery Association in 139, Iowa. Justice Waterman, speaking for the Supreme Court, agreed, reminding us that, as with so many things in life, timing matters. A spouse's statutory dower interest attaches to real property the instant there is a concurrence of season in the husband and marriage relation between the parties. While that is the normal rule regarding property, in the case of the purchase money mortgage, the situation is different. The Supreme Court said, a purchase money mortgage is a unique real estate instrument with a priority timing rule that dictates a different result. Purchase money mortgage is based on the theory that upon simultaneous execution of the deed and mortgage, the title to the land does not for a single moment rest in the purchaser. Through a legal fiction, first recognized in 1876 in Thomas v. Hansen at 44 Iowa, in the case of a purchase money mortgage, title merely passes through the purchaser's hands and without stopping vests in the mortgagee. No time in contemplation of law intervened between the execution of the deed and the mortgage. Therefore, the surviving spouse's right of dower was subject to the mortgage.
Thanks, Suzanne. So what's the takeaway? It's simple. In our fast-paced, day-to-day, deadline-driven practices, we become more focused on the how of the law and sometimes forget the theory. This case acts as a reminder that the common law is based on theory, and every now and then we have to revisit the basic concepts. Until next time, this is Nick Critelli in Des Moines. Thanks for watching.